Grant-in-aid code will be prevailed. ಅದರಲ್ಲಿ ನೋಡಿ 1975 ಪ್ರೈವೇಟ್ ಎಜುಕೇಶನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಕ್ಟ್ ಅಂತ ಒಂದಿತ್ತು. ಆಮೇಲೆ ಗ್ರಾಂಟ್-ಇನ್-ಏಡ್ ಕೋಡ್ ಅದರಲ್ಲಿ ಏನಾರು ಇದ್ರೆ then they have to challenge us because law is that it cannot be inconsistent with that
ಇಲ್ಲ ಅದಕ್ಕೆ ಅದಿಲ್ಲ. ಒಂದು ಜಸ್ಟಿಸ್ ಕೆ ಶ್ರೀಧರ್ ರಾವ್ has held one more judgment here.
What is that?
Permitted employees of private education institutions submitting request to the state government to extend them benefit of additional increment of passing Kannada language examination has held under KCS Service of Kannada Language Examination rules, which is given to employees in the state education institution. The statute providing to employees of private education institution pay parity with the employees of the government unless otherwise prescribes. The word unless otherwise prescribed should be understood as prescribed by the act and not by the executive instruction. Direction lies to the government to consider the request to frame the appropriate rules to give effect. In this regard, the employees of the private education institution are entitled to equal pay on par with the government employees under Article 39D of the Constitution to give effect the equal pay of equal work. Proviso to Section 87 of the Karnataka Education Act 1983 declares that minimum qualification to recruitment, age, recruitment to and the benefits of retirement for employees. Unfortunately, I am the only person I am stuck here.
Financed by the central government or declared by the parliament. Your is which institution?
Mine.
Now that
now PS Engineering College I am working, which they have admitted to Engineering College I am working, which they have admitted to ready to give these pensionary benefits. The service which I am rendered in the collegiate education from 19 for a period of 16 years in a grant-in-aid post. For that they are Bharati College.
Yes, Mr.
Yes, Lord.
What is your stand now?
Lord,
Either don't commit it, you make it in that writing. That what is the stand of that? Then we will decide on that.
obviously.
When do you want?
Lord, after 1 week I need
Yes.
because
This
night
matter, 16th. Yes, you
16th
make it
better.
in
16th better. Other than 16 and 17. Lord.
17th,
17 bit adon next ಯಾವ್ದ್ರ
18th.
obviously.
Yes. And also verify if there is any grant-in-aid code. If the similar provision is there, then there is nothing has been problem.
Obliged,
Pass an order on that. Yes.
Number 58, Ashokar Kalyan Shetty for petitioner, connected matter, Aditya Chakragiri.
Lord, I appear for the counsel for the petitioner 58.1.
Yes.
My lord, J. My lord.
Pension as per the government order 15/299.
Yes.
Annexure 8, page 24. They have been examined by this court.
Who will argue? You will
Wait,
argue. Even he wants to argue his case first, Mr. Ramal. Then we will hear you. Yes.
My lord, J. may kindly be seen.
Hear you. Yes.
My lord, J. may kindly be seen. After the cause title,
Yes.
page 84, my lords.
84. Yes.
Page 84, my lords.
84.
84. We had filed, my lord, contempt because he did not comply with the court order. A specific direction was given. They, my lord, we filed contempt. There they said, we have done that.
What is the directions given by this court? What is the direction given?
We have done that.
What is the directions given by this court? What is the direction given by this court?
My
First
lord,
we'll say.
page 89, may kindly be seen. 91, my lord.
What is that order we are challenging in that
ಹೌದು,
petition?
ಹೌದು.
ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
ಹೌದು. a specific direction was given,
Hmm.
my lord, to revise the pension
Hmm.
of each of the petitioners
Hmm.
in terms of, my lord, page 100, page 100, my lord.
Yes.
The writ
Now read
petition-
that direction.
The writ petition stands allowed.
Yes.
Respondent 1 to 3 state is directed to fix and pay revised pay to the petitioners in terms of the government order number, FD number so and so,
Hmm.
dated 15 to 1999.
Hmm.
My lord, there are not pausing for a moment, my lord. On 15 to 99, there were two, my lord, government.
PT.
No, one prior to 14 up to 1498, my lord, up to 31/3/1998, 2 PT. Up to 31/3/1998,
31/3/98.
3/1998,
Up
2
to
PT.
2 PT.
Yes, madam. After on or after 1/4/98, 1 PT.
Yes.
My lord, these petitioners, my lord, they all retired between 1/1/1996. Lordship, may kindly make note of these.
1996.
1/1/1996.
2 PT.
Yes, madam. 1/1/1996 to 31/3/1998.
1196.
1996 to 31/3/1998.
31/3.
Yes, madam. For this purpose,
Hmm.
my lord, after their retirement,
Hmm.
they were all, my lord, drawing UGC pay scale. My lord, along with the, my lord, the central government UGC pay scale, the pay revision was revised
Hmm.
retrospectively after retirement, retrospectively from 1/1/1996. So that is there, my lord, they form a different group.
Yes.
They all retired
Yes.
without revision of their pay scale.
Yes. Yes.
And, my lord, subsequently, government, my lord, revised the pay scale, undisputed facts. Pay scale, undisputed facts, with retrospectively from 1/1/1996.
Yes.
But, my lord, the pension was not fixed on the basis of revised pay scale.
Yes.
Yes, ma'am. So, my lord, those who retired, my lord, subsequent, those who are denied, my lord, the benefit of revised pay scale,
Hmm.
with effect from the date of their retirement, they all approach the Supreme Court. That is the, my lord, leading case, my lord, Raghavendra Achar case,
Hmm.
which is, my lord, followed by the learned single judgment,
Yes.
the coordinate bench. And these petitioners, my lord, these petitioners, they also, my lord, page 53 onwards. Some of the petitioners who are alive, my lord, have filed this petition.
Hmm.
Yes, my lord. And, my lord, that the on page, my lord, 59,
Yes.
page 59. This is with regard to revision. The Learner Council of Petitioner has filed a memo for disposal of petitions in terms of the order dated 12/5/2006, passed by the Honorable Supreme Court Civil Appeal number 1389/2006, as the facts of the case and this case are identical. See, Satyanarayana Singh, the Learner High Court government pleader, doesn't dispute this position. Accordingly, my lord, it was disposed of in terms of, my lord, that this thing. This, my lord, the Raghavendra Achar case, which is, my lord, followed by the Learner single judge.
Yes.
And, my lord, the one of the, my lord, para 26 onwards.
No, but that.
The government has government
In terms
and
of
university
possible-
suffered, my lord, the order.
1389 of.
Yes, no. The Supreme Court, my lord, turn to page 24 onwards.
Yes. Yes.
On page, my lord, para 24, my lord.
Yes.
Lordship got it? Yes. The contention of the state that the matter relating to the grant of pension benefits vis-a-vis the revision in the scales of pay scale on a different footing or stands on a different footing, thus must be rejected.
Yes.
What they said was, as the Lordship Lord submitted earlier, they retired, my lord, between 1/1/96 to 31/3/1998. But there, my lord, the revision was done, my lord, in 1999,
Yes.
retrospectively from 1/1/1996.
Yes.
Government declined to fix their pension
Yes.
based on the revision of, my lord, pay scale.
Yes.
So, my lord, they all went, they filed writ petition. Writ petition was allowed. And but my lord, it was my lord, it was overruled in writ appeal, and then my lord, they all went to the Supreme Court.
Yes.
Supreme Court, my lord, paragraph 24, 25. Then is, as is well known, is not a bounty. It is treated to be a deferred salary. It is akin to right of property. Salary payable to the employees as on the date of retirement. Now, this is relevant. Now, my lord, they want to, my lord, by virtue of my lord annexure M1, which I have produced, they want to, my lord, defeat this.
Yes.
Yes. Paragraph 26. These appeals involve the question of revision of pay and subsequent revision in pension, and not the grant of pension for the first time. Only the modality of computing the quantum of pension was required to be determined in terms of the notification issued by the state of Karnataka for the said rule 296 of the rules was made applicable. Once this rule became applicable, undisputedly the computation of pension benefits was required to be carried out or in terms thereof. The pension rules anyway says that pension should be calculated only on the basis of the emoluments last drawn. No order, therefore, could be issued which would be contrary to or inconsistent therewith. Lord, this lordship may kindly make. Such emoluments were to be reckoned only in terms of the statute rules. If the state had taken up a conscious decision to extend the benefit of UGC pay scales with effect from 1196 to the appellants, allowing them to such accrued right, such a right to draw pension to the extent of 50% of the emoluments computed in terms of the rules with effect from 1196 vested in the appellants in terms of government notification read with rule 296 of the rules. So, my lord, Supreme Court, my lord, this thing that 50% of the emoluments last drawn. Then, my lord, as the amount calculated on the basis of the revised scales of pay on and from 1196 to 31,398 has not been paid to the appellants by the state government as an ex gratia, and in fact was paid by way of emoluments into which the appellants became entitled to in terms of their conditions of service, which in turn they acquired a vested right to the pension, calculate on the said basis in terms of the implement rules. There would be reduction of pension with retroactive effect, which would be violative of Article 14 and 16 of the Constitution of India.
Yes.
So reduction of pension, Lord, if done, this was not done. So, my lord, that was done, and then they started paying out of, my lord, the last revised pay. Lordship may kindly for a moment, my lord. Annexure M1 may kindly be seen.
No, this court has already directed in terms
Yes.
of that.
Now, my lord, what has happened is annexure M1 affidavit in contempt petition.
113,
Annexure M1, my lords. Page 113.
112.
ಅದ್ರಲ್ಲಿ ಟ್ಯಾಬ್ಲೆಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇ ಡ್ರಾನ್ ಇನ್ ಯುಜಿಸಿ ಪೇ ಸ್ಕೇಲ್ ಅಂತಿದೆ ಥರ್ಡ್ ಇದರಲ್ಲಿ ಅಂಡ್ ಬೇಸಿಕ್ ಪೆನ್ಷನ್ ಪ್ರಯರ್ ಟು 1498 ಅದ್ರಲ್ಲಿ 18,200.
Yes.
That was the last pay drawn, my lord. So 50% thereof became 8,135. This they were paying. For this, my lord, for pausing for a moment, this is 50% of
saying that for this they have to add revised pay scale and they have to make 50%.
50% to the 8,135 ಆದರೆ, my lord, kindly go to, my lord, annexure A.
No, that what is that pay revised?
ಅದೇ annexure A may kindly be seen. Where, my lord, the things have been, my lord, this thing is annexure A, my lord. At page 33. This, my lord, 50% of the last pay drawn. The basic pay became 5. Otherly para 2. Our whole bad, my lord, fighting, my lord, litigation, my lord, around, my lord, is around this. To that, DA, my lord, as on 1196, sanction is so and so, dated 8596. So DA has to be, my lord, added. Then, my lord, the third one is important. 32.5% of basic pension has to be again added. First, my lord, basic pension, then dearness allowance, and then 32.5 of basic pension. And then, my lord, kindly go to 2.4. Consequent upon revision of pension with effect from 1198, the, my lord, earlier dearness was as per, my lord, as on 1196. That is one aspect. Then, my lord, consequent upon revision of pension with effect from 1198, the consolidated rates of DA admissible to the pensioners with effect 198 and are as follows. So, my lord, 16% of basic pension requires to be added. And then, my lord, 1798, 22%. So these are the things to be
50% of the pension.
How basic pension things to be
50% of the pension.
How basic pension.
Basic salary.
Basic-
DA will not be considered for that.
ಅಲ್ಲ ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಾರೆ ಬೇಸಿಕ್ ಪೆನ್ಷನ್ 16% ಬೇಸಿಕ್ ಪೆನ್ಷನ್ ಅಂತಿದೆ.
No, see, increasing DA is different. For payment of pension, 50% of your basic salary. Increasing DA is different. For payment of pension, 50% of your basic salary. Whatever that revised in that.
ಹೌದು ಬೇಸಿಕ್
DA, no, pension determination is only on the basis of your basic salary.
ಹೌದು ಅದೇ ಮಾಡ್ಲಿ
Basic
ಅವ್ರ
salary
ಪ್ರಕಾರನೇ
50%.
ಹೌದು ಅವ್ರ ಪ್ರಕಾರನೇ
ಎಷ್ಟಾರ increase
ಹೌದು
ಆಗ್ಲಿ.
ಅವ್ರ ಪ್ರಕಾರನೇ 8135 ಅವ್ರ ಪ್ರಕಾರನೇ.
No, is there any on 1/1/1998 government order? Is there any revising of salary?
1190 pay scale was revised.
Pay scale revised, then it has to be added.
ಅದು ಆ ರಿವೈಸ್ ಪೇ ಸ್ಕೇಲ್ ಪ್ರಕಾರ ಪೆನ್ಷನ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ. So according to my lord on page 113.
Therefore, what
For that, while revising, the other two things, 4 things have to be added. Revision is total of in the following. There are two, the first and sentence nodi. There are 2.1. 2.1 ಅಲ್ಲಿ the revised pension. ಇದು ಪೆನ್ಷನ್ ತಾವು ಹೇಳೋದು ಕರೆಕ್ಟ್, ಪೆನ್ಷನ್ ಬೇರೆ. ನಮಗ್ ಬಂದಿರೋದು ಈಗ ರಿವಿಷನ್ ದಲ್ಲಿ ನಮ್ಗೆ ಸರಿ ಬಂದಿಲ್ಲ ಅಂತ ಆಸ್ ಪರ್ ದಿಸ್ 15/2/99.
Yes.
Now, my lord, it has become final that we are entitled for, my lord, revision of pension as per this GO.
Yes.
It is foregone conclusion. There can't be any doubt about that. So 2.1 says ತಾವು ಹೇಳಿದ್ದು ಪೆನ್ಷನ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದ್ರ ಬಗ್ಗೆ ಏನೋ ನಮ್ದು
Yes.
ರಿವೈಸ್ ಪೆನ್ಷನ್
and family
shall be
pension
the total of the following.
who are retired on service shall be totally following basic pension, family pension 488.
Supreme Court now ಹೇಳ್ದಂಗೆ this is not granting pay, it's only the revision. When you revise it, my lords, when the state government revises the pension, it has to be the revision has to be done in accordance with 2.1. That's
Yes.
the total of the following. ಅದಕ್ಕೆ ಒಂದು ಬೇಸಿಕ್ ಪೆನ್ಷನ್ ತಾವು ಹೇಳ್ದಂಗೆ ಆಸ್ ಆನ್ 1498 ಪ್ಲಸ್ ಡಿಯರ್ನೆಸ್ ಅಲವನ್ಸ್ ಪ್ಲಸ್ 32.5 total of the following. Then comes to, my lord, 16% basic pension from 1498.
Yes.
So that goes contrary to, my lord, 50% of the ಹೋಗೇ ಬಿಡ್ತದ 25% ಆಗತ್ತ ಅವಾಗ.
ನಿಮ್ದು ಲಾಸ್ಟ್ drawn salary ಎಷ್ಟು? What is that your last
ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ 18,200 ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಇದೆ ನೋಡಿ
18,200.
ಹೌದು
ಅದ್ರ 50% ಆದ್ರೆ
ಅದು ಮತ್ತೆ 8,135 ಆಗತ್ತ ಅವ್ರ
then
ಪ್ರಕಾರ.
why they have said that 3,450? 20 why they have come to that 3,450?
ಅದಕ್ಕೆ 2 PT ತಾವು ತಗೋಬೇಕು ಪೇಜ್ 34.
ಆಯ್ತು ನೋಡೋಣ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಕೇಳೋಣ.
ಪೇಜ್ 34 and the annexure.
Yes.
Page 34 ಅಲ್ಲಿ clause 3, the revised basic pension and family pension and the revised rates of dearness allowance admissible with effect on so and so are shown in the annexure. These consolidated rates of so and so are in lieu of the dearness allowance rates admissible under GO so and so. My lord, next kindly go to page 35.
Yes.
ಅಲ್ಲಿ 195 ನಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು, ಮಾಡಿಬಿಟ್ಟು ದೇ ಎಂಡೆಡ್ ವಿತ್ 3,450. on page 36. So ಇದರಲ್ಲಿ 3,450 ಮಾತ್ರ ರಿವೈಸ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ಅವರು ನಮಗೆ they want to say malord this is the now what we get if we have to follow 15 to 1999. But malord while saying so ಇದೇ ಬೇಸಿಸ್ ಮೇಲೆ ಈ ಅನೆಕ್ಸರ್ ಮೇಲೆ on the basis of clause 3.
Class 3.
ಹೌದು page 34 ಅಲ್ಲಿ
Page 34.
the revised basic pension
Family pension and revised rates, dearness allowance.
brought into effect clause 6 ನೋಡಿ clause 6.
Yes.
These orders shall not be applicable to pensioners who were drawing immediately before retirement, pay in the UGC scales pay and who retired on or after 1996 and who have opted for central pattern of relief ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು ಅವಾಗ. This is my lord deleted, diluted. At any rate, my lord, we have become entitled for this one. 5.1 ನೋಡಿ 5.1 in case the increase in pension or family pension now admissible together with existing pension or family pension results in monthly pension or family pension exceeding the maximum admissible under government order 1 PT 1999. So my lord, now kindly go to lord 1 PT at page my lord.
ಧಾರವಾಡದಲ್ಲಿ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇತ್ತಲ್ಲ ಏನದು?
ಇಲ್ಲ ಅದೊಳಗೆ ಇನ್ನೂ ಕೊಟ್ಟು ಬಂದಿಲ್ಲ, ಅದು ಹಂಗೆ ಹಾಕಿದೆ.
ಅಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚಿಗೆ ಬಂದಿತ್ತು ಮ್ಯಾಟರ್.
ಆ ಡಿವಿಷನ್ ಬೆಂಚ್ ನಲ್ಲಿ ಇದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಇದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದು ಮಾಡಿ ಕಂಟೆಂಪ್ಟ್.
No, it is in that contempt
40.
Yes.
Now this 10,610 became my lord was amended as 11,610.
Yes.
ಅದನ್ನ ಯಾಕೆ ಬರುತ್ತೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಬೇಸಿಕ್ ಪೆನ್ಷನ್ 8,150 ಬಂತಲ್ಲ, ಅದಕ್ಕೆ DA plus 32.5 plus 16% ಮಾಡಿದ್ರೆ if it exceeds 10,000 then you shall have to be restricted to 10,610. Now what they have done is they have reduced our basic pension itself to 3,450. ಆ 3,450 ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು then they say as per note of page 36.
Yes.
3,450 ಗೆ it becomes revised to 7,691 ಅಂತ ಹೇಳ್ತಾರೆ. ಇದನ್ನ instead of 11,610 they say we are entitled, we have revised our pension to 7,691, so you are not entitled for any amount. Our position has become worse than what it was earlier.
Yes.
They have, my lord, last time also, my lord, before lordship sitting in division bench, lordship posed a question to the government as what about the 5.1. 5.1, my lord, refers to 1 PT.
Yes.
That is, my lord, where if the maximum ceiling mentioned is mentioned as 10,610.
Yes.
So if, my lord, now the Supreme Court has made it very clear.
Yes.
We are entitled for 50% of the last.
Yes.
Annexure C. Annexure C ತಾವು ನೋಡು.
Yes.
Annexure C, my lords. On page 44, my lords.
Yes.
4.1 maximum pension.
Yes.
My lord, that 11,610 becomes 19,950. ಅದು ಬರುತ್ತೆ. ಅದು ಬರುತ್ತೆ. Then my lord, it becomes annexure E, my lords. Annexure F, my lord, page 63.
ಇದೇನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್?
ಹೌದು ಹೌದು, ಅದನ್ನ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಹಂಗೆ ಡೈರೆಕ್ಷನ್ ಹಂಗೆ ಇದೆ.
ಅಲ್ಲ ನಿಮಗೆಲ್ಲ ಮ್ಯಾಕ್ಸಿಮಮ್ 11,000 and
ಹೌದು 11,610 becomes 19,950 maximum pension.
That is again revised.
ಹೌದು ಅಗೇನ್ ರಿವೈಸ್. ಅದೇ ತರ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರೋದು ಪೇಜ್ 63. ಪೇಜ್ 63 ಮೇಡಮ್.
Yes.
Melod, the
now the 39,000.
39,900. That is ceiling. Instead of 11,610, they took it as 3,450. Then that becomes 7,691. 7,690 ದಿಂದ 14,998 ಮಾಡಿದ್ರು. ಅದರ ಪ್ರಕಾರ 28 ಮಾಡಿದ್ರು. ಅದರ ಪ್ರಕಾರ 30,000 ಮಾಡಿದ್ರು.
ಆಯ್ತು, ಅದು ಫಸ್ಟ್ ಫಿಕ್ಸಿಂಗ್ ಕರೆಕ್ಟ್ ಆದ್ಮೇಲೆ
ಅದೆಲ್ಲ ಮಿಸ್ಟೇಕ್ ಸ್ಟಾರ್ಟಿಂಗ್ ನಲ್ಲೇನೆ ಮಿಸ್ಟೇಕ್ ಮಾಡಿ ಮಾಡ್ಬಿಟ್ಟು ವಿ ಹ್ಯಾವ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ದ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಂತ ಕಂಪ್ಲೈನ್ಸ್ ಅಫ್ರಾಡ್ ಹಾಕಿದ್ದು. These are all my lord produced along with the compliance affidavit. Then the my lord contempt court felt if they have followed one method, and if you say this is not correct, then it is outside the scope of contempt. So you have to get, because the order of the learned single judge, page 100 may kindly be seen. Page 100. ಆಮೇಲೆ 102 ತಾವು ನೋಡ್ಬೇಕು.
This repetition after that order complaints.
ಹೌದು, ಇದಾದ್ಮೇಲೆ ಫಿಕ್ಸ್ ಅಂಡ್ ರಿವೈಸ್ ಪೇ ಅಂತ ಇಷ್ಟೇ ಬರೆದ್ರು, ಆದರೆ ಯಾವ ತರ ಬರಿಬೇಕು ಅಂತ ಬರ್ದಿಲ್ಲ, ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡ್ ಬರ್ರಿ ಅಂತ ಅಂದ್ರು ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಔಟ್ಸೈಡ್ ದ ವಿ ಕಾಂಟ್. ಅದನ್ನ ಇವ್ರು ಆದ್ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ಮೇಲೆ ಪೇಜ್ 102 ಅದು ಲಾಸ್ಟ್ ತಾವ್ ನೋಡಿ, ಡೆಪ್ಯೂಟಿ ಕಂಟ್ರೋಲರ್ UAS GKVK ಬೆಂಗಳೂರು ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಇದೆ ಅದಕ್ಕೆ. 102 ಗೊತ್ತಿತ್ತು ಅದು, ಇದು ಇದೆ ಸ್ವಾಮಿ. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಫ್ ಪೆನ್ಷನ್ ಅರಿಯರ್ಸ್, ಮ್ಯಾನೇಜರ್ ಡಿ ಆದ ತಕ್ಷಣ H ಆದ ತಕ್ಷಣ
Annexure L.
ಕ್ಯಾಂಪೇಡ್ 16,25,728 ಬರ್ಬೇಕು ನಮ್ಗೆ.
Where you are reading page?
ಅಲ್ಲ 102 101 ಆಗುತ್ತೆ.
101. 102 is that annexure L.
102 ಮೇಲೆ
annexure K 101.
annexure K. ಇದು annexure K ಮೇಲೆ ಅವರೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ, ನಾವು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ ಮೇಲೆ ದಿಸ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಅಲಾಂಗ್ ವಿತ್ ಹಿಮ್ ಲಾಟ್ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಇದು ಒಂದು ಬಂದಿದೆ, ಇಷ್ಟು ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ. ಅದಕ್ಕೆ ಮಾಡ್ಬಿಟ್ಟು 16,25,000 ಅರಿಯರ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು, ನಾವು ಕೊಡೋದೇ ಇಲ್ಲ, ನಾವೇ ವಾಪಸ್ ತಗೋಬೇಕು ಅವ್ರ ಕಡೆಯಿಂದ, ಬಿಕಾಸ್ 3,450 ಮಾಡಿದ್ರೆ ಅವರೇ ನಮ್ಮ ವಾಪಸ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅಂತ ಬಂದ್ರು. We have paid higher amount ante. One more submission was made by the university was, my lord, we 60 annexure D may kindly be seen. Annexure D, my lords. Annexure D, sorry, annexure E, my lords. Annexure E, page 61. Page is correct idanilla.
Yes.
Page 61, my lords. Last sentence. My lord, the teachers, last but one para, mele, preamble dalli. The teachers of US Bengaluru and Dharwad, your lordship got it?
Yes.
The teachers of US Bengaluru and Dharwad in the representation read that my lord, in the earlier Supreme Court judgment is referred to, that Raghavendra Acharya judgment to nam cases judgment to refer ಮಾಡಿದ್ದಾರೆ. So ಅದರಲ್ಲಿ ಅವರು ಬರೆದಿದ್ದಾರೆ 50% ಮೇಲೆ stated that pension benefits shall be given to the teachers who have retired during the period from 1/1/96 to 13/3/98 on the basis of 50% of the last pay drawn by them, so and so in civil appeal, so and so. So they too admit, my lord, that we are entitled for 50% of the last pay. Requested the government to extend the pensionary and monetary benefits as contemplated in the government order number dated Bangalore, dated to 13/11/2006, and consequent arrears at the earliest. My lord, this pertains to 2 PT, not 1 PT. My lord, US government university, my lord, repeatedly says that we had made a request for and extend the benefits of 1 PT, which is not correct. My lord, subsequently, then government issued the order dated 16/5/2007, para so and so. Then my lord, next para 2. The basic pay drawn in the revised UGC scales of pay by the assistant professor senior scale, assistant professor selection grade, assistant so and so, I'm sure, who retired during the period from 1/96/13 shall be reckoned as emoluments under Rule 293 KCR for the purpose of calculation of pension benefits admissible under the provisions of KCSR. Concerns with Supreme Court of India. ಎಂಬಲ್ಮೆಂಟ್ಸ್ ಏನಿರುತ್ತೆ ಅದನ್ನ ಅವ್ರು 5th ಬಂದೇ ಬರುತ್ತೆ ಅಂತ ಒಪ್ಕೊಂಡಾಗೈತೆ. Then, my lord, with regard to our representation to extend the benefit of 2 PET, the university, the government, my lord, said the revised benefits available to state government employees with effect from 1198 as per GO number FD special 1 PET date 99 dated 15th shall be extended to this so and so ಅಂತ. ನಾವು ಕೇಳಿದ್ದು 2 PET, ಅವ್ರು ಕೊಟ್ಟಿದ್ದು 1 PET. ಅದಕ್ಕೆ ನಾವು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. 2006 ನಲ್ಲಿ ನಮ್ಗೆ ಕೊಡ್ಲಿಲ್ಲ.
No, that in the writ petition it has stated 2 PT.
ಹೌದು 2 PT ನೇ ಕೇಳಿತ್ತು. ಅದಕ್ಕೆ London single judge also granted the 2 PT, page 100.
Yes.
And in the course of that, my lord, a categorical finding is given till the date of, my lord, the disposal of the writ petition, that is on 1/7/2021.
Yes.
The benefits as per 2 PT but not given. And they had filed statement of objections, and very same lot of the documents were produced. University now and then says, aವಾಗ 1 PT ಕೇಳಿದ್ರೆ ಸ್ವಾಮಿ ನಾವು ಕೊಟ್ವಿ, ಇಲ್ಲಿ 2 PT ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೆ 1 PT is more, my lord, beneficial ಅಂತ ನಮ್ಗೆ ಅದು ಬೇಕಾಗಿಲ್ಲ. ಯಾಕಂದ್ರೆ 1 PT ಇದಿಲ್ಲ.
Yes.
32.5 ಇಲ್ಲ ಅದರಲ್ಲಿ. ತಾವು 1 PT ತಾವು ನೋಡಿ. Manager B, my lord.
Yes, we'll continue.
Yes, my lord.
Yes, Mr. Ready. Page number is not tallying.
ಎಲ್ಲ ಹೇಳ್ಬೇಕು ನೀವು ಬಲಿಯರಂತೆ ಎಲ್ಲ. ಆಯ್ತು ಮಾಡ್ಕೊಟ್ರು. ಐ ಆಮ್ ಸಾರಿ, ಐ ಸ್ಟ್ಯಾಂಡ್, my lord, correct. ಆಯ್ತು ಕೊಡಿ. ಆಯ್ತು.
You want?
57.
My lord, reply filed by
ಸಾಹೇಬ್ರೆ ವೆಂದು 2355
reply filed by university is very clear, Lord. They have extended PET 1 only.
No, that is what they have to be clarified. Because
Yes.
earlier sections of this code, it is 2 PT.
Yes.
Lord, I will assist this court.
Yes, let them complete that argument. No, therefore they are given a number 1 and 2.
ಅದ್ ನಾ ಹೇಳ್ತೇನೆ. ಹೇಳಿ ಹೇಳಿ, ಯಾಕೆ ಇದೇ ತರ ಹೇಳ್ತಾನೆ ನಾವು ಕೊಟ್ಟಿಲ್ಲ.
43 ಸಾರಿ ಕಂಟೆಂಪ್ಟ್ ನಡೆದಿದೆ. ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಬಂದಿದ್ದಾರೆ, ಈ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬಂದು ಎಲ್ಲರೂ ಬಂದ್ ಆಗಿ ಆಮೇಲೆ ಡ್ರಾಪ್ ಮಾಡಿರೋದು. ಇಫ್ ಯು ವಾಂಟ್ ಚಾಲೆಂಜ್ ದಟ್, ಟೇಬಲ್ ಹಾಕಿದ್ದಾರೆ ಅವರು ಎಷ್ಟು ಕೂಡ. ದೇ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಫಾರ್ ದಿ ಗವರ್ಮೆಂಟ್ issued a GO 2007. Then, my lord, they came back to the PET 1. 86 lakhs rupees arrears has been paid.
No, then why you are kept quiet when this court has directed to consider under 2 PT?
My lord, we are under the impression that not been implemented PET 2. This GO, my lord, is came to only before the, my lord, when the affidavit has been filed by the finance department in the contempt proceedings. Then, my lord, we came to know that calculation
To seek for review of that order.
My lord, review of that order. Now, the order of the court, PET 2 pursuant to the Supreme Court judgment should be implemented. It may go up, it may go down. Now the government says after calculation, if you paid the excess pension, you recover from them. If you are liable to pay,
That after they have given a letter to show that give it 1 PET. This court, thereafter that there is in a directions. You don't want to seek modification.
even till today, PET 2 less than the PET 1 only.
ಇಲ್ಲ ಇಲ್ಲ, ನಾವು ಕೊಟ್ಟಿದ್ದು
No,
2
no, no.
PT ನೇ. 13/11/2006 ಕೊಟ್ಟಿದ್ದು 2 PT,
No,
not
they-
1 PT ಅಲ್ಲ.
My lord, I will furnish the tabular statement. Even till today, PET 2 less than PET 1 only. They less than PET 1 only. They continue to till the disposal of the writ petition, higher pension. Now you drawn 86 lakhs arrears and continue to draw. 2013 you paid, filed the writ petition seeking to PET 2. Even till today, my lord, PET 2 less than PET 1.
No, you are saying that you are giving under PET 2.
Please,
Please show me that is calculation is in terms of that or not.
Yes, calculation is government has given a last index 3000. Government is ready to file an affidavit.
No, if it is not calculated in
Contempt
terms of
under
government
some
order,
court
then I
is
ask them to go to the civil court. We have to be decided.
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಪೆಟಿಷನ್ 409 ದಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗ ತಾವು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಫಸ್ಟ್ ಯೂನಿವರ್ಸಿಟಿ ಸೇಸ್ ಮೈ ಲಾರ್ಡ್ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಡೂ ಇಟ್.
Yes.
ಗವರ್ನಮೆಂಟ್ ಸೇಸ್
18th.
Obliged.
Please. Yes. Read this matter on
18th. But 18th.
29, Vijay Raghava Sarathi.
What is this matter?
Only short point, Lordship. Appeal whether it is maintainable before the municipal commissioner of municipality or before the state. As per the regulation, it has to be before the municipal commissioner. If the order is passed by the chief officer.
Under section
342.
Previous matter, it was 1819, my lord.
Sorry,
19.
Appeal against which order?
Appeal against an order of dismissal.
Previous matter,
passed by the authority.
1819, my lord. 19.
340.
19.
Yes, ma'am.
Not 19th. It is Friday. 22nd.
Yes, ma'am.
Yes.
19th.
Yes.
Next year, we preferred an appeal before the municipal commissioner. He says that it is not maintainable, he returned the file.
No, by
As
against
per the
that,
provision,
imposing penalty.
penalty of dismissal. To fine, reduce, suspend or dismiss or to impose any other punishment on the holder of any post to which the municipal commissioner or chief officer has a power to appoint. Subclause 2, when a municipal commissioner has been appointed under these provisions of this act, all other officers or servants of employed by the municipal council shall be subordinated to him. 343 is important. Orders to appeal. No appeal shall lie to the municipal council in respect of any order passed or anything done by a municipal commissioner in the exercise of powers conferred upon him or by under the provisions of this act, except in the case of an order passed anything done by him under the following provisions, namely. Your Lordship, get it in 9, 11 Ali, clause C, subsection 1 of section 342 in respect of an order of dismissal. If it is passed by the municipal commissioner, it is before the state. Here, the order of the president or vice president to a committee. C is very important. To the municipal commissioner, subclause 11, any order of clause sub C, subsection 1 of section 342 in respect of an order of dismissal.
Your case is dismissal.
My case is dismissal. I have been compulsorily dismissed
Yes.
by an order passed by the chief officer.
Yes.
By authorization of these rules, I preferred an appeal before the commissioner of municipal Ramnagar. He issued an endorsement, annexure A.
Yes, Mr. Government.
That is the only
We'll
point.
file our objections, my lord.
No,
Instructions
whether
are-
appeal is maintainable or not, why do you
That
want
is the
to
only
appeal?
point.
Only
Because
you
he
see
says that before him appeal is not maintainable. Rule says that it is only he who is,
appealable. That's all. That.
because I am without job for the reason that
See, whether that is the provision, other than that, it is very 42 is for a punishment. Appeal is provided under the rules. Other than that, if there is any amendment to these rules.
no,
This
it is
the
not.
what it is. That is what you have to be seen. Day after tomorrow.
Day after. ನಾಳೆನೂ ತಗೊಳ್ಳಿ ತೊಂದ್ರೆ.
ನಾಳೆ ಬೇಡ. ನಾಳೆ ಆಗಲ್ಲ. Monday.
Monday, please.
Just verify that. That's all.
It may be in
Unnecessary
preliminary
is-
hearing, Lordship. That is the only point.
Yes,
If they
pose this matter on Monday's preliminary hearing.
oblige.
If you ask him to come and answer that. Yes.
So if he has been exercised by the municipal commissioner, I will go before the
Yes.
government. If not,
63 Chandrakant Argole. 63 Chandrakant Argole.
Yes, 25th.
64 Javed S.
For the petitioner, my lord, that this matter already has been disposed, my lord. I sought only for the correction, my lord, in respect of the survey number, my lord.
Hearing hige ಯಾಕೆ ಬಂದಿತ್ರಿ ಕರೆಕ್ಷನ್ ಮ್ಯಾಟರ್
Please, my lord.
why it is posted for hearing?
Disposed on 24 January 2020, my lords. Subsequently, I filed a memo for correction, my lord. After that, I have filed review petition, my lord, which has been allowed and writ petition has been restored, my lords. And subsequently, I have filed amended the petition and I have carried out in the petition also, my lords, amendment.
Then why it is coming before me when it is petition is
Disposed by this, by your
that order is
lordship.
recalled?
Please, my lords, it is recalled, my lord, restored, my lords.
Special order ನಮಗೆ ಹೆಂಗ್ ಬರ್ತದೆ review?
That's-
Why
This
this
order has been disposed by Milords.
ಆಯ್ತ್ರಿ dispose ಆಗಿ recall ಆದ್ಮೇಲೆ review petition recall ಆದ್ಮೇಲೆ why
The Your Lordship, Milords.
dispose ಆಗಿ recall ಆದ್ಮೇಲೆ review, it has to go before the roster bench, mister.
Not
It
from
is
the
not
roster bench,
criminal
it has been posted here only.
Roster
Milords.
bench said it has to be before.
Please,
Why?
Milords, because the order has been disposed by Your Lordship,
It
Milords.
has been recalled, then again it has to be heard afresh.
No, Milords, in the respect of only correction, Milord, that is.
Yes, let us see that, yes.
Not-
Post this matter in order.
Raghavendra Gayatri is hearing.
Yes, this matter, when do you want?
But any early date, it can be disposed of.
25th.
We are ready.
68 Chandini GS.
Yes,
To file my
Ready.
statement of
We
objections.
were ready for final hearing.
yes, ready,
Yes, my lord, we are ready for final hearing.
yes. What is that matter?
I have to file my statement of objections
Want
also.
to file objection? Yes, at the request of counsel for the respondent. When do you want? How much?
24th, 25th, Your Lordship.
Yes,
It's been a
25th.
year, they had not filed objections. That's why matter was posted for final hearing, my lord.
What is that matter?
It's a dismissal matter.
Dismissal.
Dismissal, then matter requires hearing. Yes, 25th.
Great.
Grateful.
Fast over
My lord, I am sorry, my lord, seal number 63, my lord, a date may
Yes.
kindly be given. This emergency, we have moved the matter, my lord.
Date has given. Yes, all matter I am giving date, Mr. Yes,
Serial number 40, Shyam Sundar. Complaints.
yes. Office objection is, yes, madam.
My lords, there is urgency of stay in this matter, my lord.
What is that urgency?
My lords, the Directorate of Medical Education issued the notification for the recruitment for the post of director in Jaideva Institute of the, first notification, there are the applicants who applied for this post. In the meantime, as per this court order, they have left the notification, my lord, that is annexed the page number 34, stating that page number 34 and third line, my lord.
Yes,
And also in view of order of the Honorable High Court in writ petition number 26761 of 2024, the notification dated 12/1/2024 regarding the appointment to the post of director of Jaideva Institute is to be withdrawn, and it was decided to issue fresh notification for appointment of director of so and so. My lords, here the respondent number 3, they did not carry out any amendment of any bylaws. They have issued the second notification. Same notification without carrying out any changes, they have issued the second time, and it was issued on 26/6/2025, and tomorrow they have called out for the interview, my lord.
yes, Mr. You have filed an affidavit before the court saying that after that amendment will issue. Now you have issued that without amendment.
Jaideva ಅವರು
After that amendment will issue. Now you have issued that without amendment.
Jaideva ಅವರು Jaideva Institute.
See, state government has filed an affidavit, state that for the completion of the entire process stated above, that period of 3 months is required to complete that process. In the affidavit, the state government has stated that certain amendment to the bylaws of that institution would be necessary as suggested by the governing council, and amendment to that bylaws, fresh notification recruitment of the post of the directors would be issued. A short 3 months time to complete that process. Before amendment, now it has been issued. Where is that? There is no amendment. Where is the notification? Qualified person has to come to that interview.
Yes, my lord.
Where is that? Second notification.
Minimum qualification.
Yes. Yes, Mr. Will stay that.